Good day, my name is Kenneth Chin, and today we will be talking about estate planning. Before we get into the discussion today, I would like to explain that the relationship between attorney and client is a serious issue, and as such, I want to make it clear that the material in this presentation is for the purpose of general information only, and it is not for the purpose of providing legal advice. You should have personal contact with an attorney to obtain legal advice with respect to any particular issue or problem which you may have. The delivery of, use, and access to this presentation does not create an attorney-client relationship between myself and you who are receiving this presentation. The aim of this presentation is to expose participants to some options which are available to you to protect your health, wealth, assets, and your wishes. In the course of our discussion, we will be looking at insurance, power of attorney, disposal of asset by will, intestacy, asset disposal, inter vivos. I know that some of these terms may not be familiar to you. However, during the presentation, you should develop a better understanding of each of these terms and how they can benefit you when securing your estate. The presentation is grounded in certain laws of Jamaica, and they are the Probate of Deeds Act, Wills Act, Status of Children Act, the Inheritance Provisions for Family and Dependents Act, the Intestates, Estate and Property Charges Act, and the Administrator General's Amendment Act 2015. All these acts which are listed are available on the National Police College of Jamaica eCampus website, and the link to the website is on the screen. This presentation will last about 2 hours without a break. The session is pre-recorded, and as such, you are to write down any questions which you may have, and they will be answered as best as possible at the end of the presentation, where we will facilitate a question and answer session. As members of the JCF, during your working life, you will accumulate assets in different forms as part of your financial portfolio. When doing financial planning, some members neglect proper estate planning, which is an integral part of the process of financial planning. The concept of estate planning is best understood as a process of making proper arrangements for the protection, preservation, and provision of a person's total assets for the benefit of his or her family and loved ones. Now, what is your estate, you might ask? The estate, for the purpose of estate planning, can be simplified to mean all the property and all the property rights that a person owns. And we know that property may be in various forms. It may be a piece of land that your grandmother leave you up a country, or your father may have a piece of property, or you might have a motor vehicle, or you might have some jewelry that you have that are very expensive, or you might be a person who is inclined to the arts, and as such, you might have a video or a movie or a clip that you created or some other intellectual property. Now, all these combined would form a part of your estate, and as such, you need to develop a plan how you will protect your estate so that your children and your children's children can benefit from your hard work. So, who needs estate planning? Now, the general concept is that some police officers don't, don't do any planning at all because they say they don't have anything to leave. They don't have anything to put in their will, or they don't have any property, they don't have any vehicle, or they may have a one vehicle or a one house and a one child, and as such, they don't think that it is necessary to do estate planning because it is clear in their mind who should get their estate. However, there are, if you fall in any of these categories, you need to do a plan for your estate. So everyone who has a minor child has assets that you would need to distribute, that would need to be distributed on your debt. The general rule is that the spouse will get title to many of your assets, but not all of your assets. Thirdly, if you have health issues or you have specific desire on health care. Fourthly, if you have preference on funeral or burial desires. Now, some of you may ask the question, who is a minor child? So according to Jamaican law at present, a minor child is any person who is under the age of 18. The law also makes provision for children who are above 18 and under the age of 23. However, we will discuss those further in the presentation. The assets which you have, you might have a specific asset. For example, your father died leaving a property in your name, but you have siblings who your father really wish that the property would stay in the family. So in order to ensure that that property goes to your father's children, you would need to make proper provisions for that to for the asset to fall there. Otherwise, it may go to your spouse and your siblings would not benefit from your father's property. When you look at healthcare issues or specific desire on healthcare, if you fall in a situation where you have a critical illness, you might find that much of your assets are used trying to keep you alive. And as such, you might not have enough for the benefit of your children should you pass on after. Also, you might not want to remain on a life support machine for a prolonged period. And if you do not plan from now how to deal with these issues, you may have problems later on and your desires may not be fulfilled. We know that in the JCF, it is a norm for when an officer dies in the line of duty or as long as he's serving, that the JCF plays an integral part of the funeral planning and burial. But if you are so minded that you don't want those ceremonies to take place, you can put it down in writing that how you desire your funeral proceedings to go after you die. So what would happen without a plan? So the first thing is that your children could end up with guardians who are not appropriate to take care of your children. Poorly titled asset could go to could not does not go to the rightful person. So if you don't make a proper disposal of the assets during your lifetime, it may not go to the person who you really want it to go to. Much of wealth could be lost in transfer costs and taxes, which if you do these things in your lifetime, it could cost less other people who are to benefit from the assets from your estate. There is also the issue of major delays in the distribution of assets if your estate is contested. So your children may not benefit immediately if there's a dispute over who is to get what part of your estate if something should happen to you. First thing that we're going to discuss in your estate plan will be insurance. Why buy insurance, you might ask? The first thing is that when you buy insurance, what you are doing is actually transferring the costs of a potential loss to the insurance company in exchange for a fee known as a premium. There are some type of assets which normally you would insure based on the laws of Jamaica or based on how you come in possession of the asset. For example, if you buy a motor vehicle and you are operating the motor vehicle on the roadway, you would need to insure the vehicle as a part of the laws of Jamaica. Yes, even police officers need to insure their vehicles. I know some of you might be driving your vehicles and don't insure it because you are of the view that other police officers won't give you a ticket or prosecute you for not having insurance for the vehicle. But think about what would happen if you are involved in an accident. If you are involved in an accident with the vehicle and someone is injured and the cost for damages to that person is substantial in the millions, then what would happen now is that when the person wins the case and you don't have insurance, what the court will now do is to look at your other assets. So you might have a house, you might have a piece of land somewhere, you might have some other property or other assets, and you might lose all of those assets because you did not buy an insurance policy for the vehicle because you believe that as a police person, as a policeman or woman, you can get away or get around the law and not thinking about the impact that it will have or that it can have if something goes wrong. The next thing we are looking at is also home ownership. Now in Jamaica, there is no requirement for your house to be insured. However, if you have a mortgage on your house, then it is usually a requirement from the mortgage company that the property is insured because the mortgage company is ensuring that they secure the money that they are lending you. The other type of insurance we look at is health insurance. Now, as a member of the JCF, as long as you are enlisted from training school, you are given health insurance through, in my days, it was Blue Cross, now it is Sagicor. And what that does is that it subsidizes the cost of your health care. I don't know if any member of the JCF would exercise the option of stopping their health insurance. But if you are thinking that way, I would advise against it. I would also advise that you look at additional health insurance to cover critical illnesses so that if you have a problem, a major medical problem, your other assets don't have to be used in order to try and bring you back to health. Because if you don't have health insurance, you might have to sell your car, sell your house, sell other assets in order to provide for your health. Now, if you are healthy, that is the time to buy insurance because when you get sick, the premium would be so high that it would normally be out of your reach. So when you are healthy and strong and fit, buy insurance and it is cheaper. Buy health insurance when you are healthy. The final type of insurance that we will look at is life insurance. Whenever you take a loan from a mortgage company or from a bank or other financial institutions, it is a usual practice to insure the loan. This is good because what it does is that if you die before the loan has been paid off in full, then the insurance company would come in and pay the balance of your loan. Now, what would happen if you die without insurance is that your estate, the assets in your estate, would have to be used to pay off the rest of your loan. One loan which is not usually covered by insurance are credit cards. So I would advise you that if you have a credit card, ensure that you have it at a level which you can afford to pay so that if something goes wrong, your assets, your estate is not dwindled down in trying to pay off your credit card or other uninsured loans that you might have at various institutions. It is never a good idea to just buy an insurance policy from you join the work in 1996 or long time and you have developed in your career and your life has changed and you have not reviewed your insurance policies. Now the question is when should you review your policies? Now this list is not exhaustive, but generally you should review your policies whenever there's a change in your life. For example, you get a new job. So you might be serving the JCF today and you see greener pastures and you decide to take on a new job elsewhere. When you take on that new job, it is advisable that you look at your portfolio, look at your insurance policies and see if they match where you are now. Promotion, vex issue in the JCF, but it happens. When you are promoted, you need to look at your insurance policies and see if you need to review anything on your policies. Every asset that you acquire, you need to see if there is an option available that you can use insurance to protect that asset. As I said earlier, the laws of Jamaica doesn't force you to insure your home, but the home is probably the biggest asset that you would acquire in your lifetime. And as such, think about whether or not you want to leave that to chance. When you have children being born, it is always important to make provisions for these children. And sometimes you might have some policies with some of your older children because you were basically forced to buy insurance in your younger days. But now that you have grown mature and you have freedom of choice, you don't realize that some of your children you have not bought proper insurance for them. And of course, children, and we have to look at the spouse. If you have a new spouse, you need to also look at whether or not the person named as beneficiary on your insurance policy was your old spouse. And what would happen if something happens to you and your policy has the old spouse on the policy and the new spouse who is doing all the run up and down and taking care of you while you are sick and going through. And at the end of the day, the person named on the policy is not the person you are currently with. So as long as you change your spouse, then you should review your insurance policy. And outside of change of spouse and these other things listed before, there may there might be a situation where the person who you named as a beneficiary, who is officially known as the nominee, you would want to change the beneficiary. For whatever reason, you might have your mother on it, your sister as the beneficiary, and they might die before you. And if you leave them on it as the beneficiary, what would happen is that when you die, this benefits or what is paid out from your insurance would go to the estate of the person who you named, even though they are dead already. So you have to ensure that you review your policies from time to time to ensure that the persons who are beneficiaries on your policy are the people who you want on the policy, and also all your assets that you have are protected through insurance. I know that talking about estate planning is usually difficult for members because usually it is associated with death or some major injury or something else that is not very pleasing to talk about. But we have to face it, these things happen. As members of the JCF, our job is very dangerous. And as such, we might leave and thinking that everything would be fine, and we end up in a shootout, or we are driving, the vehicle may crash, or something can happen, and you might die, and you might also live. Now, we are looking at what will happen to your assets, or how do you protect your assets, if you end up in a situation where you are alive, but you lack the mental capacity in order to deal with your asset. And there is a case that we look at, which we will see how we would treat such a scenario. Now, in this case, we call the person Inspector Lucky Star. So Inspector Lucky Star has a very hostile relationship with his wife, and they are separated for the last 6 years. Both Inspector Lucky Star and his wife have moved on with their lives, and he has been he has done well for himself during his career. He is the sole owner of 3 premises which he has used for rental purposes, and the proceeds from rental he used to supplement his salary and care for himself and the 6 children which he has. Of note, none of the 6 children are for his wife. Just last week, he was in a major accident and his mental capacity is severely diminished and he is unable to make any decisions at all. Now, naturally, you know what happened next. The wife steps in and takes control of the assets and the healthcare. Now, in spite of the fact that they are in a hostile relationship and that both of them are separated and moved on with their lives, the fact is that they are still married. So, unless Inspector Lucky Star made a plan to deal with his estate during his life, then the wife would have all right to step in spite of the relationship which Inspector Lucky Star and his wife had. Now, in order to prevent such a situation from affecting you, what would you need to do? And I know some of you are answering and giving some responses, and I hope that you choose the option of looking at a power of attorney. So we're going to discuss what is a power of attorney. So a power of attorney is an instrument by which a person who is known as a donor formally authorized another person who is known as the donee to act on his behalf or as his agent in all matters or for a specific transaction or a particular type of transaction. So for Inspector Lucky Star, there are certain things that faced him in the scenario or in the case we look at. One is his health care. What should happen in terms of his health care? Unless you write it down to say what you want to happen, what will happen is that somebody else will decide what happens. So you might acquire the so Inspector Lucky Star who acquired the three rented premises, he might not want any of them to be sold in order to bring him back to good health or to continue his medical treatment. Inspector Lucky Star may want to not to be resuscitated. But if he did not leave those instructions, then it would be left to the wife in this scenario who could make those decisions. And if even if she is not acting in his best interest, for somebody else to host her authority, it would mean that that person would have to go to court and get an order from the court. And we all know how the court system is and the time that it may take to get an order. So during all that time, what may happen is that Inspector Lucky Star wife may do what she pleases, which might not be beneficial to Inspector Lucky Star's estate. So in this particular case, what we realize is that the person who Inspector Lucky Star have a hostile relationship with literally has his life in her hands. And do you want a situation like that to happen to you? Now, to prevent this, what you need to do is to ensure that you develop, draft, talk to an attorney, go to somebody who can do these things for you. Get a power of attorney done so that you can ensure that your wishes are carried out. Because if you don't, then you really don't know what will happen if a situation occurs. The power of attorney allows the donee to act in the interests of the donor while still alive but incapacitated, so the estate is maintained and does not lose value. Now, in this case that we're looking at, Inspector Lucky Star's wife may do just this, saying that she doesn't want Inspector Lucky Star estate to devalue. So she might say, okay, pull the plug, and then she now would end up inheriting a lot of the assets of Inspector Lucky Star, the fact that she is the wife. So you have to be careful who you appoint as the donor and who you want to manage your estate. So for a power of attorney to be lawful, it needs proper execution. And in terms of execution, we talk about the who needs to sign it. So this is one document that you are the person who makes the declaration and you sign the document, and it can be executed in the presence of a notary public, a justice of the peace, or an attorney at law. Now, the thing about a power of attorney is that you can only make a power of attorney while you are still lucid or while you still have the mental capacity to make a power of attorney. So if you are a minor, you cannot make a power of attorney. Or if you end up in Inspector Lucky Star's situation where you're, you have diminished mental ability, then you would not have the capacity to do a power of attorney. In spite of not having the capacity, if you might have a situation where a person could be blind because of some reason or another, and the power of attorney is drafted, and the person doesn't know what is on it, cannot see what is there, but he gave some instructions on how it is to be done. So as long as what is in the power of attorney is done with the knowledge of the person doing the power of attorney, who is the donor, then it could be legal, and it must be approved by the donor, and it must be free from undue influence. So it might not be a good idea for the person drafting the power of attorney to have the donee, the lawyer for the donee, come and draft the power of attorney and give the donor to sign. So that may be a situation of undue influence, so you have to be careful whether or not who appoints or who hires the lawyer that does the power of attorney, because it could fail if it is the donee who gets the lawyer. Now, when does a power of attorney expire? Now, the power of attorney can be revoked. So you can write in the power of attorney that you can revoke the power of attorney at any time. So you can create a power of attorney today, and tomorrow you decide that no, this is not the right person that I need. So you can simply do another power of attorney and revoke the previous power of attorney. Additionally, if you have a power of attorney going, if you die, the moment you die, the moment the donor dies, then the power of attorney cease to apply. So the power of attorney would expire on the death of the donor. The third area that we will be looking at is the disposal of assets by will. And I know most of you, when you see the topic estate planning, the first thing you think about is, oh, this is a presentation about will. So while will is one of the areas, and it will form a big chunk of the presentation, but it is not the only thing. And we have already looked at two of the areas that you need to look at to protect your estate or to plan for your estate. We are now moving into the third area. So what is a will? So generally speaking, a will is a legal document that sets forth your wishes regarding the distribution of your property and the care of any minor children. And of course, we know that is after you die. A will is important because a will, if you to maximize the likelihood that your wishes are carried out, you want a will that sets forth in writing, that is set forth in writing and signed by you and your witnesses. The laws of Jamaica have very strict rules as it comes to how a will should be executed. And while the rules are there and you might go to court and prove that even though you don't fall within the rules of the law, then you might still get the will probated. And but in order to prevent that lengthy process, then you want to ensure that the will is executed properly. So if your will does not meet the standards or the formalities, then your instructions may not be carried out. And what are these formalities? And we looked at them when we were looking at the powers of attorney, the power of attorney. So the standards are similar. The will needs proper execution. The person making the will must have the capacity to make a will. The person must have knowledge of what is in the will. They must approve the will. And of course, there should be no undue influence. So again, the person who is the beneficiary of the will, cannot get a lawyer to come in and draft the will for the testator. So the person writing the will is known as a testator, and the person who is to get the benefit is known as the beneficiary. So if the beneficiary gets the will, get a lawyer, write up the will, write that all the house, the townhouse, the mansion, the vehicle, all the property must go to her or him, and then goes to the testator and say, oh, if you don't sign the will, then you know that I'm going to left you, or some other threat, whether it be some emotional withdrawal or some other things. And we know that sometimes the women withhold things from the men, and this can be seen also as undue influence if it is used to influence the will. Why make a will? When you make a will, you can ensure that if you have specific directions that you want for your funeral, that it is carried out. It also gives you sole discretion over who is to get your assets. And we will discuss further this point because there are some rules that prevent you from disinheriting some persons who are dependent on you. But generally, the will gives you sole discretion over who gets your asset. In your will, you can make provision for your children, whether they are adults or minors. And of course, we know that dead left land cause all sort of problem as long as you are serving in the constabulary force at police station. You know that a lot of family tension are brought about because of dead left land. So in order to minimize the tension between survivors, you leave a will so that it is clear who is to get what, and they're not left to fight over your assets after you pass. If you have charities that you usually provide for, you can leave assets or leave gifts for your charities after you die, and you can put those in your will as well. Now, people don't like to make will, as I said before, because of the fear of death or the thought of death, but a will is unnecessary, and it is a necessary and usually fairly simple process that can save your family time, money, grief, and can give you peace of mind. So make your will. There are certain things that you need to know that your will does not cover. And some of them I know we discussed earlier. The first area that we covered, we looked at insurance, and we know that if you have a nominee or beneficiary on your policy, that the proceeds of your insurance policy does not go to your estate. It goes to whosoever is on, who's named as your beneficiary. Also, retirement assets, you are also required to state who should get your retirement assets normally. Any asset that is owned as joint tenant with right of survivorship does not go to your estate. What that means is that if you have a property and you own it with your sister, for example, as joint tenant, and even though you paid 75% of the cost of acquiring the property, and your sister put 25% of the cost, but because you were not aware of the difference between joint tenants and tenant in common, your attorney basically put joint tenant on the title. And then during your lifetime, you have your spouse in the house, and you and your spouse put extension and addition to the property and all that and expand the property. And then, God forbid, something should happen to you, and your spouse now who is left there would say, okay, I know that my wife or husband had the property and he paid 75% and we spent millions of dollars to expand the property. What happens is that because it is joint tenant, it goes to the sister who is named on the property. So even if your wife or husband write it in the will that on his or her death, the property should go to you, it would not go to you because it is not covered by a will or joint tenancy. It goes to whosoever survived the longest. They are the owner. Also, there are investment accounts that are designated as transferred on death. So there are some assets that you acquire that as, as soon as you die, they transfer to someone else. So those don't go to the will. And there are other examples which you can think of which does not cover on that are not covered under the will. The next thing we are going to look at is how do you prepare a will? The first question is, do I need a lawyer to prepare a will? As an attorney, my answer would be it is best to get a lawyer because there are certain rules that govern the making of a will to make it legal. So in order to prevent, in order to ensure that your wishes are carried out, it's best to speak to someone who is legal minded so that they can guide you properly. However, if you choose not to go the route of a lawyer, I am giving you some general information. I remind you, it is not legal advice, but there are some things that you need to do if you are preparing a will for yourself. The first thing you need to do is to write a list of all your assets and debts, or what we call liabilities. And the government has made it easy for us because every year you have to do a declaration of assets and liabilities. So if you have been honest in your declarations at the end of each year, then it should be relatively easy for you to write a list of all your assets and liabilities. So if there are any assets which you acquire after you did your declaration, you just add them to the list. I would never imagine that you would leave off any of your assets and liabilities of your declaration. So we are moving right along. The next thing, you are to include the contents of your safety deposit box if you have any, if you have one, or any items of sentimental value, or you might have some jewelry that is handed down from your great grandmother and you want to ensure that it goes to your daughter. You need to ensure that you write down these things. And other assets that you wish to transfer to a particular person or entity. As I said before, some of you might be charity oriented and want to give a gift to the Friendly Society or some other agency, United Way. You might want to give a $2 million to United Way. So you have to put that in your will. You also need to identify your witnesses, your executors, and your trustees. Your witnesses can be anybody. So your witnesses are just two people who you can get in a room with you to sign together. So all three of you need to sign the will at the same time in each other's presence. Important people who form a part of your will are the executors and your trustees. It is not a legal requirement, but it makes a lot of sense to have at least two executors. My advice is that one of your executors should normally be an attorney or someone who can manage the legal aspects of your estate, and the other person is someone who is a very close family member, even if they are a beneficiary of the will. The executor can also be, if you have your will and you have two people who you basically given all your assets to in equal shares, then you can name the two people as executors and beneficiaries of the will. So you need to look at your, depends on your assets, your peculiar set of assets that you have, and and your beneficiaries to determine who you want to be the executor of your estate. If you have children, you want to also name trustees for your estate in order that if you if your children needs to attend school or some of your assets need to be to go to your children, because they are if they are minor children, they cannot inherit the assets until they become adult. So your trustees would basically take control of those assets on trust for the benefit of your minor children. Now the executors cannot be the same persons as the trustees. So generally speaking, you would need two witnesses, two executors, two trustees, because what you'd want is that if one of your executor or trustee dies, you want to ensure that the surviving trustee can carry on your wishes. So it is normally good to have one of your executors relatively young so that they are likely to outlive you. So when you're choosing your executor, don't choose two people who in their 80s and 90s who probably cannot, even if they survive you, they don't have the energy and the agility to go to court to file the documents to get your estate probated so that it can be distributed. So you have to be very careful in the choice of your executors and trustees for your will. The witnesses, as I said, can be anyone. If your estate is substantial, ranging in the millions of dollars, or your situation is legally complex, even though the slide is saying you may wish to enlist the services of an attorney, I would say ensure that you enlist the services of an attorney. And on a point of note, do not use the pharmacy will forms because those will forms have caused serious problems in the court, and a lot of people use those will forms and the will cannot be probated or the will forms are not structured properly. So it is better to just get a piece of paper, foolscap paper, make your quarter inch margin as you normally do, quarter page margin, and you just write that, just write all the things. So you have your house there, you want to give to John, you have your car there, you want to give to Mary, you have this there, you want to give to that person, and you just write out all your assets and say who is to get them. Write out how you want your funeral to be. You want to be buried wherever, as long as it is legal for you to be buried at that place. So you state where you want to be buried. You want a sepulchre built in the shape of a motor vehicle or an airplane. You can do all of that in your will. Write it down. And at the end of the will, you just ensure that you have the signatures of your signature and two people witnessing your signature. If you don't name an executor or a trustee, if you don't name an executor on the will when you're writing the will, then your will somebody else has to take charge of your will, and it would be similar to if you die without a will, in a sense that somebody have to come in that you don't know, that you did not appoint. So it could be your spouse or your child, depending on your particular situation, who would need to get letters of administration with your will annexed so that they can get permission to act in the space of what would be an executor to carry out your wishes. So, what do you do with the will after you prepare it? It is interesting that some people believe that after they make the will, they should put it in a safe, lock it up under combination, and nobody knows that the will is there. So, how can your wishes be carried out if nobody knows that you have a will or where the will is? So, I know that you have the answers to this question. However, let us go through them. So, when you prepare the will, you sign and date it in the presence of your two witnesses, as I said before, and then you hand over the will to your executor or to one of your executor and or your attorney. This will ensure that if something happens or when you die, your executor is in a position to act on your will immediately. Because what you don't want to happen is that after you put in your will that you want certain funeral arrangements and all of that, and because nobody knows, you are buried or cremated, and you never wanted that to happen. And as such, you might not have peace in your grave or in your ashes. Now, generally, a point to note is that generally any will that is made prior to you getting married is revoked when you are married and a new will is needed. So if you have assets and you made a will, and in your will you made provisions for your two, two children that you had, and later on you get married and you made no provisions for your wife in the will. Now, well, whether or not you made any provisions for her when, say, she was the sweetheart before, or you were dating and then you later on get married. Section 13 of the Will Act says that as long as you get married, your will is revoked unless the will is made in contemplation of marriage. So if you have someone who you intend to marry and you write on the will that in contemplation of being married to you, you are leaving this person your house or your car or whatever is there. So unless those or similar words are used, then the will be revoked as soon as you are married. So for all of you who made a will before and then you got married, remember that the will is now revoked, and as such you need to make a new will. As a reminder, you know that the person who makes the will, if it's a male, is known as the testator, and if it's a female, the testatrix. The characteristics of a will is important to determine whether or not what is actually written in the will is likely to go according to the wishes of the testator. First characteristic of the will is that it is not restricted to the disposal of property. As we discussed earlier, a will can be used or normally used to appoint your executors, to appoint trustees of your will. In addition, it is normal practice that when you make a will, there is a clause in your will to say that this will revokes all previous wills which you have made. This clause is very important because ultimately you can only have one will. So you might have other documents which form a part of the will. So a will can be a composition of 4 or 5 different documents which come together to make your will. So if you do not have the clause to say that you revoke all previous wills, that means that you might have a situation where you have 2 documents which come together to make the last will and testament of your last will and testament. Additionally, in your will, you can appoint guardians for your minor children. So you might identify someone who you want to act in your stead after you pass on. As discussed also, you can give funeral directions as to your burial, your cremation. If you want your organs to be used for scientific research or you want to donate your organs, you can put all of that in your will. And interestingly, if you have been following the news and look at the situation with Toots, where some family members wanted Toots to be buried at Dovecot, other persons wanted him to be buried at Clarendon, and the culture minister ultimately saying that he is to be buried at Heroes Park. Now, if Toots made a will and put in his will that I want to be buried at Clarendon or wherever, then his will would have to be carried out. But, be- but because based on evidence that we have so far from the news, it doesn't appear as if he made a will. So, as such, other persons are deciding where his final resting place will be. The second thing about wills is that it is only a declaration of the testator's intention. What this means is that the testator can say in his will, I leave my house to my darling wife, and before the testator dies, the testator can in fact sell the house while he's alive, even though the house is named in the will, because the will is only a declaration of his intention. So, additionally, the executor, if when you look at the liabilities of the person's estate, if there isn't enough money to pay off all the lawful debts of the testator or the deceased at that time, then the executor may need to sell some of the assets in order to pay the liabilities of the estate. So even though you might have been named in the will as a beneficiary to receive the car may have to be sold to pay for the liabilities of the estate. So it is only a declaration of the testator's intent. The third point is that the will takes effect upon the death of the testator. And there is a Latin term which is not very important, but it is there. But what you need to know is the principle is that it takes effect on the death of the person. So an example, if the testator has a will and in the will he gifted a piece of property to his son John, and John has a daughter named Jill. Now, if John dies before the testator, the gift does not go to Jill, who is the beneficiary of John, but in fact, the gift reverts to the testator. So even though John is named to get the house, if John dies before the testator, then the legal term that is used is that the gift lapse, and that is found in section 19 of the Wills Act, is that if the beneficiary dies before the testator, then the gift lapse. And when we go on to the intestacy, you would see that there is a difference between the gifts that pass by will and what is entitled on the intestacy. But at this point, you know that if the beneficiary dies before the testator, then the gift lapses unless the testator said that if John dies before me, then the gift passed to someone else. So the testator, so you would have to put in your will that you don't want the gift to lapse. So if you don't state in the will that if John dies, then the gift goes to Jill, then the gift will not go to Jill. So you have to be careful of that when making your will. And even if you have someone who is named in your will who died, then you need to probably review your will or make a new will so that you can make provision for the asset, for that particular asset. Fourth thing is that a will is ambulatory, which means it is movable. And similar to that, it is only a declaration of the intention of the testator. The fact that the will is movable or mobile, it means that the testator is entitled to do anything he wants with his property while he is alive. So the testator can sell, can assign it to someone else, can give it away, or otherwise dispose of the property while he is alive because the will is movable, it is mobile. Additionally, a will is capable of capturing assets which are not yet in the possession of the testator. So if the testator, for example, made a will in 5 years ago, for example, you made a will 5 years ago and you say, all of my real estate I leave to my daughter. And after you made the will, you purchase two more property. What would happen is that even the properties that you own after the will, it would be covered in the will because because of the way you word your will. So if you say all of my property, it means all property which you now own or which you acquire later on. So you have to look at how you word your will to ensure that it captures everything that you own. The next thing is that a will is you can revoke a will. So if you make a will and you write a clause in the will that this will is irrevocable, the court will ignore that clause because as a part of the characteristics of a will is that it is always revocable by a competent testator. Remember, we listed some things that you must have in order to make it valid. So as long as the person is in proper, is not meant, not doesn't have a mental defect at the time that they are revoking the will, that means that the person can revoke it at any time and make a new will. So the last thing is that barring exceptional circumstances, the will must comply with statutory formalities. And we know that it must be in writing, it must be executed in a particular way, and it must be free from undue influence, etc. So those are the 6 characteristics of a will. Now earlier we said that in a will you have sole discretion on how to dispose of your assets. And when I made that point, I said that there are laws in Jamaica that put some restrictions on that. And to illustrate this point, we are going to look at another case. So in this case, Sergeant Fruitless died leaving a will where he left his entire estate to his sweetheart, Main Squeeze. On Sergeant Fruitless' death, he had two children, and he also died leaving his wife. And what importantly in this case is that the wife and the two children were dependent on him, and he made no provisions for them in the will. In addition to his wife and the two children for his wife, he also had a child who is 11-year-old with his former girlfriend, Old Squeeze, and he made no provision in the will for neither Old Squeeze nor the child who is age 11. Now, generally speaking, you would have freedom to dispose of your assets however you feel. However, the statute or parliament intervened and say it would not be fair, or it would not be in the best interest, or it would not be of justice for this to happen. And as such, there is an act known as the Inheritance Provision for Family and Dependents Act. And at section 4, subsection 2, it lists some persons who may apply to the court for what is known as reasonable financial provisions. So even though these persons are not named in the will, they can go to the court and say, hey, testator or the deceased now, I was dependent on him for support, and he died, made a will, and did not make proper provisions for me. And as such, I want the court to make an order that I need to be given reasonable financial provisions. And who do you think fall in this category? Well, naturally, the first thing that would come to your head is the child. Or some people may say, well, it must be the spouse. So they both are listed as persons who are entitled to apply to the court for reasonable financial provisions. Important to note that it is not a right for you to get reasonable financial provisions. It is based on the discretion of the court. So it means that you would have to prove to the court that you were dependent on the person for financial support, and as such, you need to get reasonable financial provisions. So the wife or the husband, child, and in the law it speaks to child as even if the child is in the womb, or a person under 18, or a person who is under the age of 23 and attending school. And school is general. So I use the word school, but you know it means college, or vocational institution, as long as they are pursuing some form of education, continuing education. Also, parent of the deceased, if the parent or parents were being maintained by the deceased at the time of the death. So if you were taking care of your mother and you made a will, made no provision for your mother, and you pass on, your mother can go to the court and say, hey, I was dependent on Fruitless for financial support, and he died and he left nothing for me, and I want reasonable financial provision. So, additionally, a former wife or a former husband, let us just say a former spouse, if that person was maintained by the deceased and remained unmarried, So you may see some people who happily divorced and seem not to be able to move on with their life, and they are being maintained by the former husband in terms of what is popularly known as alimony, or even if it is not a formal arrangement like a postnuptial or a prenuptial agreement, it could be a situation where the husband or the wife just continue to maintain the person. So that maintenance would continue even after the person died. They can apply for reasonable financial provisions as long as they are not married. So when they get married, all of that gone through the window. So when they get married, they have no right to come to the court to apply for reasonable financial provision. And also, in addition to the wife or the husband, we know that the common law wife or husband also qualify as being a spouse. And we know that, well, we should know that for common law relationship, it must be a single man with a single woman or vice versa in a relationship which the general public will view as a sexual relationship. So as long as there's a single man with a single woman in that relationship for a period no less than 5 years, then they can get a declaration from the court that they are the spouse of the person. And after they get the declaration that they are the spouse, they can apply for reasonable financial provision. So based on the Act, the likely provisions are as follows. Firstly, main squeeze, who is the person who is named in the will likely benefit from some of the estate, but not all. Secondly, all the children who fall in the category of being either in the womb or a minor or under the age of 23 and attending school are highly likely to benefit from the estate of, of the testator. And this is both the children for the wife and the children or child which he had outside of the marriage. Mrs. Fruitless, who is the wife, is likely to benefit since, based on the case, it says that she was dependent on him for support during his lifetime up to the point of his death. And lastly, Old Squeeze, she would have no claim to his estate because she would not qualify as a spouse, the fact that he is still married. The fourth thing we are going to look at is what is known as intestacy. And to illustrate this point, we are going to look at another case. In this case, Sergeant No-Will died without a will. He is survived by Apple, who is his wife, from whom he has been separated, and she is now living with another man in a sexual relationship for the last 6 years. He's also survived by Ginger and Pepper, who are his children, ages 18 and 25, and they are born from the union between No-Will and his wife Apple. It was always his desire for them to get all of his assets, but based on the case, he did not put it in his will. Sugar, who is No-Will's sweetheart, with whom he has been living with in a sexual relationship for the last 6 years is also a survivor. Pierre, age 19, is the child of Noel and Sugar. Noel is also survived by Jack and Jill, who are Noel's parents. So the question that we asked is, how will Noel's assets be distributed? The fact that Noel died without a will, in law it is said that he has an intestate estate. When, if you die without a will, the state or the government will oversee the distribution of your assets. That is, that the government will distribute them according to a set formula. Now, there is a misconception that if you die without a will, then all your assets go to government. Or government take over all of your assets, and your wife and your children and other people do not benefit from your estate. Now, this is a false notion, and as such, you should wipe that from your mind. Even though it is important for you to be able to stipulate how your estate is distributed, even if you die without a will, there is still hope that your beneficiaries will benefit from your estate, even though not in the manner that you may want them to. In this particular scenario, we see where Noel wanted Ginger and Pepper to get all of his assets. However, because he did not put it in his will, we will see how the formula says that the assets are to be distributed. So when you die intestate, it can have serious implications though, because what will happen is that it can result in the sale of the family home or other assets, which can negatively impact the surviving spouse and also your children. If this is done, it can create financial and emotional difficulties, particularly if your spouse was counting on the bulk of your assets to maintain his or her standard of living. Further complications can arise if your children are minor, as the court will appoint a representative to look after their interests. And for those of you who are familiar with intestate estate, we know that it is the Attorney General who steps in and takes control to secure the asset of the minor. Or not the Attorney General, the Administrator General would step in and take and look after the interest of the minor in an intestate estate. Now, earlier we spoke about the set formula that the court uses to determine who gets a portion of the estate. But before the assets are distributed, whenever there's a minor on the estate, the Administrator General would be the person who applies for letters of administration, because the Administrator General would step in to secure the interests of the minor. However, where there is no minor on the estate, there are a set listing, as they say, who can apply to be the administrator of the persons of Sergeant Noel's estate. And this list is found in the Civil Procedure Rules at Rule 68-18-1, which lists out the order of priority to say who can apply to administer the estate. Now, the first on the list is the spouse, and we will elaborate further to say who is the spouse in this situation. Next on the list is the children or grandchildren, and grandchildren is conditional, and collectively the children and grandchildren are known as issues, and we will see under what circumstances they become an issue of Sergeant Norwell. Next you have the parents, the siblings of full blood, and their children, which is no Sergeant Norwell, niece, nephew, etc. But for the purpose of this presentation, we are going to focus on the first three, which is the spouse, children, and grandchildren, since spouse, children, grandchildren, and the parents of Sergeant Norwell, since in most situations it doesn't usually fall outside of these three categories of people. The distribution of Sergeant Norwell's estate would be based on the formula set out in another piece of legislation, which is known as the Intestates, Estate and Property Charges Act. In this act, it defines a spouse and how and what the spouse is entitled to. So at section 2, subsection 1D and E, it says that a spouse includes two single persons, and single in under this act includes a widow or widower or a divorcee, and they must be of opposite sex living together as husband and wife. Now, and the emphasis is man because it gives a longer definition, but in summary, this is what it says. Now at section 4.1, at item 1, it lists out what the spouse is entitled to. So the first thing is that the spouse is entitled to all personal chattels, absolutely. Importantly, or you might ask the question, what are chattels? What are personal chattels? The law defines it in the act, and I won't list out all of the things that are there because you can look at it. It is posted on the eCampus website, but it includes things like the motor vehicle. So if the spouse, so if Sergeant Norwell has 5 motor vehicles, all those motor vehicles would go to the spouse. Absolutely. So no share go to any of the children, nor anybody else. All of them go to the spouse. As long as it was not used for the purpose of some business. So if Sergeant Norwell had a business and he had a vehicle which was a part of our business, then that would not go to the spouse, but that would go to what is known as the residue of his estate. So things like furniture in the house, jewelry, paintings, all those things are known as personal chattels. So all of those things, the wife would get everything. Next, the wife is also entitled to $10,000 or 10% of the net value of the estate, excluding the personal chattels. So when you look at the whichever is greater, so it's if the net value of the estate, if 10% of it is more than $10,000, then the wife gets 10%. If the 10% is under $10,000, the wife gets $10,000. And the spouse is also entitled to interest on point number 2 above until it is paid. Interest at 10%. Now, in addition to the personal shuttle and the $10,000 interest that the wife is due, after those are taken from the estate, what is left is known as the residue. The residue of the estate could be a house, a piece of property, other things. Those things form the residue of the estate. So in addition to what the wife gets already, she's also entitled to the if there is no issue or no, in this case issue means children or grandchildren in certain conditions. So if for ease of reference we'll refer to issues as children until we move on to the next slide. So if there are no children, so if Sergeant Noble had no children and he had no parents who were living at the time of his death, then the spouse is entitled to 100% of the residue. If there is one child alive, then the spouse is entitled to 66.66% of the estate, or 2/3 of the estate. If there is more than one child in the estate, surviving child, then the spouse is entitled to half of the residue of the estate. If there is no children, but the deceased died, leaving parents, one or two parents, then the spouse is entitled to 66% of the residue of the estate. The next thing we are going to look at is the issue or children of the estate. Now, there are two categories of issues. So the Act speaks under Section 2 of the Act. It says that the child of the deceased, including those born in wedlock and out of wedlock, or children who are adopted, or children in the womb, are known as child of the deceased or issue. Section 4, subsection 5 says that a grandchild of the deceased may also fall in the category of an issue only if the child died before the decease. Now, when we were looking at wills, we learned that the will, if the child is a beneficiary of the will and the child dies or the person dies before the testator, then the gift would lapse, so it would go back to the estate. Under this law, if you have a child and the child dies before the person who has the asset, so if the child dies first, the gift doesn't lapse. The gift now falls to the grandchild of the deceased. So for example, if the child, so if the deceased had two children and one died, and that child that died had two children, the share that was supposed to go to the child that died would be divided equally with the two children who are alive, which are the grandchildren. So what is the share? that they get. So if you look at item 2 under section 4.1 of the Act, it says that a share of the residue which the issue is entitled to is if there is no spouse, then the issues would get 100% of the estate. If there is spouse and one issue, that is one child, then the child or issue would get 33% of the estate. Because we remember earlier we said that the wife or the spouse would get 66.66. So the remainder would go to the issue for those who can do maths. And of course, we also said that if there is more than one child, then the wife or the spouse already get 50%. So the remaining 50% now would be divided equally among all the children or the issues that survive. So if there are 4, it would be 54, 4 equal portion of 50%, which is about 12.5%. Now, when is a parent or parents entitled to a share of the estate where the person died intestate? So under the Intestate Estate and Property Charges Act, Section 4.1, Item 2, the residue to which a parent is entitled to is as follows. Firstly, if there is no spouse or no issue, that is no spouse, no children, and the parents, if there is one parent, the one parent get 100%. If there are two parents alive, they get 50% each. If there is a spouse and there is no issue, then the parents would get equal share of 33.33% because we know that the spouse gets 66.66%. So in summary, based on the scenario with no will, so the spouse of no will, the fact that there is more than one children, it means that the spouse would get 50%. And we know that the spouse is apple and not sugar. So even though Sugar was the person actively engaged in the life of Noel, the fact that he's still married, it means that Apple would be the spouse and she would be entitled to 50%. Now the issues, so ginger, pepper and pear, regardless of the fact that some children are born of the marriage and some born outside of the marriage, it is equal share of the 50% that each of them would be entitled to. And also important to note that it doesn't matter the age of the children when it comes to intestate estate. So in a previous slide, we learned that it would be only minor children or children who are under 23 and attending school. It is not so for intestate estate. All the children, whether they are adults or minor, they are entitled to a share of the estate of the person who dies intestate. And the parents in this scenario, as long as there are issues or children in the estate, parents get nothing. So the only way the parents can benefit from the estate is if the deceased died without issue. So as long as there are issues or children, the parents get 0%. The final point we are going to look at is the disposal of assets inter vivos. And illustrate this point, we are going to look at another case. In this case, Corporal Morning has a 23-year-old daughter, Jem, with his late wife, Ruby. Ruby, prior to her death, purchased a house with 100% of her money and left it to Corporal Morning in her will. Ruby's dying wish was that her daughter Jem would own the property on the death of Corporal Morning. Corporal Morning has five other children who are under the age of 18. I know that many of you looking at this scenario will be thinking that because Corporal Morning has five children under 18, they are minors and as such, they would have to be entitled to a part of the estate, the entire estate of Corporal Morning. You might also be thinking that if Corporal Morning creates a will and doesn't make adequate financial provisions, then then Jem might not benefit from the estate of her mother because as the case suggests, Jem is 23-year-old and as such might not be protected under the law. So in this scenario, you would have to look at other options in order to ensure that the estate passes to Jem because this was the wish of Ruby. So in order to have this done, you would have to do what is known as inter an inter vivos transfer. So what is an inter vivos gift? Because this is a term that we have been using over and over during this presentation, and you might be wondering what does this mean? So an inter vivos gift is a gift between living persons. That is, a gift that is made during one's lifetime. So based on this scenario, there are some options available for Corporal Morning to ensure that Jem benefits from the estate of her mother. And we're going to look at two of the options available, even though there are many other options, but these are the more popular options that you would explore. So the first option is that Corporal Morning could transfer the land to himself and Jem as joint tenants. Now there are advantages and disadvantages to doing this type of transaction. For example, if Corporal Morning transfers it to Jem and himself, there's a possibility that Jem could want to disenfranchise Corporal Morning from the property even before he dies. And this was not the wish of Ruby. But in addition, if Corporal Morning wants to, for example, take out a mortgage on the property, then Corporal Morning would need the consent of Jem to take out the mortgage because they own the property as joint tenants. Especially the fact that Jem is an adult, then he would not be a trustee of the estate. So Jem now would have to give consent for the mortgage to be taken out in that scenario. The second option that we look at is that Corporal Morning could also draft or create what is known as a settlement or a settlement that can be revoked. So he could transfer the property to himself for life will remain to Jem, and he could put a clause on it that it can be revoked by him at any time. So what this does is that it protects him from Jem during his lifetime from acting against his interests. So during his lifetime, he can deal with the property and handle the property how he sees fit. And then when he dies, it would automatically go to Jem and it would not go to his estate because he would have transferred it already to Jem indirectly in this settlement. So the question is, why not include this property in Corporal Morning's will? And we know from previous discussion that if it goes in the will, it is not a guarantee that it will go to Jem because so many things can go wrong. One is that if the estate is not sufficient to pay for all of the expenses and liabilities of Corporal Morning, then this property may be sold in order to pay off debts. In addition, if Corporal Morning did not make sufficient provision for the children, the minor children which he have, then the court could rule that reasonable financial provision should be made for them, and as such, the asset, this piece of property, could be sold as well to provide for these children. So, with that said, we have come to the end of this presentation, and during the discussion, we looked at insurance, we looked at power of attorney, we looked at how to dispose of property by will, intestate estate, and asset disposal by inter vivos transfer. Estate planning is very personal, and your choices will be dependent on your unique situation. It is important, however, for you to look at your assets, look at your liabilities, and ensure that your estate is protected in the event that you are seriously injured or if you die suddenly. It is not always easy to talk about estate planning, but it is a very important and critical part of your financial management. With that said, are there any questions?